Hear ye, hear ye, hear ye. The Court of Appeals for the First District of Texas is now in session pursuant to adjournment. God save the Constitution and this honorable court.
Now is where I say, please be seated. As we are all seated, I'm going to announce the case and then I'll take the announcements of the parties. This is case number 01-19-00519 Taylor Morrison of Texas, Inc. and Taylor Woodrow Communities League City Limited versus Andrew Kohlmeyer and April Kohlmeyer. And I understand, I believe that we sent both parties an announcement that this would have 15 minutes aside for argument. And I understand that Mr. Wilkerson will argue for Taylor Morrison and has chosen to have 12 minutes and 3 minutes. Is that right? 12 minutes to 3, save 3 for rebuttal?
Yes, Justice Guys.
Okay, thank you so much. And so then we'll, and Mr. Faubus will speak for the Kohlmeyers.
That's correct, Your Honor.
Okay, great. So if we're all ready, then Mr. Wilkerson, it's yours. You have 12 minutes. And I do want to add this one little thing. If we end up for some reason going over because the judge has asked you a question and you haven't had a chance to finish the answer, please do quickly finish the answer. But if we end up having some colloquy and go over a bit, then I'll add that same amount of time to the other side. We're not going to cut you off right in the middle of a sentence or an important point. But hopefully this will be adequate time to address what we need to address. So, Mr. Wilkerson, whenever you're ready, I need to get a pad. All right.
May it please the court, Carl J. Wilkerson for appellants. Thank you for the opportunity for us to present oral argument in this case. Let me begin by on this Bastille Day, offering a bon fête national to any of you with a French background or a Francophile. And let me next then go to what the Texas Supreme Court said in the In Re Weekly Homes case, quote, a non-party cannot both have his contract and defeat it too, close quote. Now here, appellees argue that they have no signed contract to arbitrate. And they did not expressly claim a contract or breach of contract in their petition against defendants or appellants. Therefore, appellees argue that they may bring and resolve their claims in court. Appellants argue, first, when appellees brought their claims to court, appellees' claims speak for themselves and they sound in contract. Not a new or independent contract without an arbitration agreement, but the written April 13th, 2013 purchase agreement for the construction of a residential single-family home at 4835 Piaris Lane, League City, Texas, in accordance with this purchase agreement. That purchase agreement is the contract in this case. That purchase agreement includes a paragraph dispute resolution arbitration agreement therein.
So you're saying that the benefit they receive from the purchase agreement is the existence of the house itself?
Not only that, but also the claims that they are asserting against appellants in this case.
Which claims actually arise out of contract?
The breach of implied warranty of good and workmanlike construction claim, the breach of implied warranty of habitability claim, as well as the negligent construction claim. Those are the only claims that have been expressly asserted in plaintiff's petition in this case. And I will explain how each and every one of those claims sound in contract. Now, when appellee sued appellants based on that contract. Appellees subjected themselves to that contract's terms, including paragraph 11 obligation to resolve their claims in arbitration. That is the direct benefits estoppel rule. It's recognized and applied by the First Court of Appeals in its D.R. Horton versus Mitchell memorandum opinion. Compliments to this court as the chef of that opinion. And thank you to Mr. Justice Lloyd as a member of that panel, since that opinion feeds both parties' arguments today. Now, appellants rely on the meat of that opinion.
Which terms of the contract are the Kohlmeyers seeking to enforce?
The Kohlmeyers seek to enforce the implied warranties of.
Is that a term of the contract? Now, the implied warranty, it sounds in contract. It is of the nature of a contractual claim. That does not necessarily mean that it is tied to the purchase agreement, which has its very explicit terms and very defined parameters. For instance, fraud sounds in quasi-contract. It is not a negligence claim. In the same way, the implied warranty sounds in contract, but is not necessarily tied to a specific purchase agreement or specific contract. Which terms, explicit terms of the purchase agreement, are the Kohlmeyers seeking to enforce?
Let me recite from the Texas Supreme Court's certaintied opinion that is cited in appellant's reply brief. Quote, "We have concluded that a warranty which the law implies from the existence of a written contract is as much a part of the writing as the express terms of the contract."
You need to keep your voice up. Be closer. Stay. Don't get away from your microphone. We can't hear you.
Yes, sir.
Okay.
And so appellants argue that the implied warranties themselves are terms of the contract. They are not expressed in the actual purchase agreement, but by law, they are inserted as what has been called as a gap filler by the Texas Supreme Court in the Centex versus Beecher case. And then as a part of the contract, according to the Texas Supreme Court in the Nguyen case, NGHIEM, that is cited in appellant's reply brief at page 10. So to answer your question,
those authorities established that there is a contractual or implied contractual cause of action. Do you have any authorities that apply that in the arbitration context? That say that now makes the arbitration, that a downstream purchase, that first of all, a downstream purchaser, and the Kohlmeyers here are at least two purchasers downstream, are bound by an arbitration agreement which they were not a signatory to.
That rule is what we ask this court to recognize. Now, this court in the Stanford Development Corporation case recognized something similar to this rule when the court recognized that plaintiffs in that case were suing on express and implied warranties. And there, in that case, this court recognized that the only, quote, the only contracts giving rise to any express or implied contractual duties in this case are the earnest money contracts between Stanford and the individual homeowners, close quote. And that was authored by Chief Justice Raddick. And so that would be the only case that I can cite to this court today that has any semblance of the rule that appellants ask this court to recognize.
Okay, Counselor, maybe you can help me out here, because I always thought the warranty of habitability was kind of a free-floating contour out there that exists independent of the contract. That is to say, it's not a creature of the contract, and that is to say, it exists without reference to the contract. I mean, can you help me out there? Am I incorrect in that belief?
The Texas Supreme Court in the Gupta versus Ritter Holmes case.
But that was a summary judgment case, wasn't it?
Yes, sir.
All right. Now, the problem I have with this is that the arbitration clauses are they're kind of talk out of both sides of the mouth. They're very favored in the law because for judicial economy, but at the same time, we're binding. There has to be an existence of a contract, because you're giving up, the persons entering into or are bound by an arbitration agreement are giving up their right to the court system. They're giving up their right to have access to the courts. So that's kind of a strict interpretation kind of invitation we have going there. So I've made a little chart. Your client is the purchasers in this one are the third parties bought the house, kind of downstream a bit. So we're struggling with making them subject to a term that gives up their access to the courts. And that's what we're struggling with here.
The court should not struggle, because when I said the appellee's claims speak for themselves, they are claiming benefits of the contract. And let me move ahead.
I thought that I just said I thought the contour is to require implied warranty of habitability for latent defects was a creature not necessarily created by a contract. It's a cause of action that doesn't require contractual adoption. I mean, I know it was specifically disclaimed in this contract, but I'm not. Are you trying to say that the purchasers in this case are also subject to the disclaimer?
No, sir. No, sir. We appellants argue that the implied warranty of habitability, just as the implied warranty of good workmanship, is implicit in the contract. That is what the Texas Supreme Court said in the Gupta versus Ritter Holmes case. That was not an arbitration case. But if the Texas Supreme Court says that an implied warranty of habitability is implicit in the contract and is therefore equitably assigned to a subsequent purchaser of the home, then it is still a contractual claim. It is not a free-floating contour.
This is where we get into some difficulty in trying to mix and match these various precedent. So Gupta was not dealing with downstream purchaser, nor was it dealing with an arbitration clause. So you're now arguing that there is an equitable assignment, yet the very explicit terms of the contract say there cannot be any assignment unless it's in writing and signed by Taylor Morrison. So where is the assignment, the express assignment that is required by the terms of the contract?
Mr. Justice Kelly, there is no express assignment. There is an equitable assignment as recognized by the law and by the Texas Supreme Court in the Gupta versus Ritter Holmes case, which did involve a subsequent purchaser.
Well, so there was not quite as downstream as this subsequent purchaser here. But if the contract doesn't specifically prohibit equitable assignment, but it says an assignment can only be valid if it is in writing and signed by Taylor Morrison. Now you're asking us to, and presumably Taylor Morrison drafted this original purchase agreement. Now we're trying to infer not just an implied warranty, but also a right to assign, which was specifically disclaimed by the written contract. So now we're building not inferences, but two different implications. And you're asking us to craft a new rule to hold the non-signatory bound by an arbitration clause based on two implications, at least one of which was specifically disclaimed by the writing that Taylor Morrison signed.
Yes, Your Honor, because the law implied that implied warranty as a term of the contract, just as another term of the contract, as you referenced, that prohibits equitable or prohibits assignment.
Kelly's got a point there that the contract explicitly disclaimed the implied warranty of habitability, yet you're trying to say that their claim of implied warranty arose under the contract, which may be a good summary judgment argument, but that's not what we're doing here. You kind of say you kind of have both ways. It's implied, but it's disclaimed. So we're going to ignore the disclaimer and say their claim rose under the contract.
Well, according to the Texas Supreme Court in the Centex Holmes case, a party cannot disclaim the implied warranty of habitability.
Yes, that's right. That's right.
So we're just simply relying upon the appellant's claims. We're not arguing the merits of their claims. Just by virtue of the appellees making those implied warranty claims and the negligent construction claims, they are making claims on the contract. They're seeking direct benefits of the contract.
I think we've gone 3 minutes over. So we will add 3 minutes to Mr. Faubus's time. So Mr. Faubus, it's over to you.
Thank you, Your Honor. So what Taylor Morrison is seeking to do here is to force my clients to have to arbitrate their claims with a third party, thereby incurring tens of thousands of dollars in arbitration fees, in addition to the already very expensive expert fees and attorney's fees that are required to prosecute a case of complexity like this. Now, and they're asking you to do that based on an argument that the Texas Supreme Court has never recognized, and no other court of appeals, including this one, has ever recognized. The Justices Lloyd and Kelly were exactly right that the implied warranties that Taylor Morrison says derived from this contract, or the contract with the original owner, are disclaimed and waived, or at least they claim to be disclaimed and waived in the purchase agreement. Now, it is very hard to waive or disclaim a claim for warranty of habitability, but it can be done. There's certain language that conspicuous language that has to be put in the waiver that specifically says what the defect is and things of that nature. But so the idea that it can't be waived is not exactly correct.
Has to be noticed. You need to post it somewhere where the people of the subsequent purchasers
right.
are notice of it.
Right. But the point remains that Taylor Morrison sought to disclaim and waive those implied warranties in the very contract they're saying those implied warranties derive from. Now, and that argument by itself is very, is very problematic. But it's important to keep our eye on what the standard is here, because what we're talking about is the direct benefits principle. In other words, is my client obtaining direct benefits from the original purchase agreement with the original owner of the home? And what the law tells us about that is the Texas Supreme Court in Weekly Homes says very clearly, claims must be brought on the contract and arbitrator if liability arises solely from the contract, or must be determined by reference to the contract. On the other hand, claims can be brought in tort and in court if liability arises from general obligations imposed by law. Now, what Taylor Morrison's argument is that because the Texas Supreme Court in Gupta said, well, these implied warranties are implicit in the original contract. Their position is that we are therefore receiving a direct benefit. Well, that's not what the law says. First of all, when we plead for implied warranty, breach of implied warranty, that's all we have to say. We say that there exists an implied warranty of habitability and good and workmanlike conduct, and that they were breached. We do not have to refer to the.
Can you distinguish the certainty case upon which Taylor Morrison relied, that the implied warranty is as much a part of the writing as any other term?
Well, first of all, that case, is distinguishable for many reasons. I don't believe that it was a case dealing with a subsequent owner of a home, but I can't tell you off the top of my head. But still, though, if a implied warranty does derive from a contract, what the courts tell us still, though, is that it's an independent claim. As Justice Lloyd said, it's true. It is an independent common law claim. It doesn't matter that it derives from the contract. So as this court said in the Steer Wealth Management case, if a plaintiff's right to recover and her damages depend on the agreement containing the arbitration provision, the party is relying on the agreement for her claims. See, we don't need to plead to the purchase agreement in this case. We didn't do it, and we don't have to do it. All we have to do is plead implied warranty without reference to the purchase agreement. That is not part of the pleading requirement for that claim. And in that case, in the Steer Wealth Management case, this court said, if, however, the facts alleged in support of the claim stand alone and are completely independent of the contract containing the arbitration provision, and the claim can be maintained without reference to the contract, the claim is not subject to arbitration. We do not have to refer to or rely on the purchase agreement with the original owners in making our implied warranty claim. That's just the fact.
What about negligent construction? How is an implied warranty claim different from a claim for negligent construction?
Well, there are a lot of similarities. The negligent construction is just, whether or not the builder deviated from the standard of a reasonably prudent builder in building a home. And you can find language on the implied warranty of good workman work that's very similar. But it is a common law claim, just like the implied warranty is. And remember, these courts, this is what courts say routinely. And we've cited tons of cases on this direct benefit theory. To be a direct benefit, it is not enough, however, that the parties claim relate to the contract that contains the arbitration agreement. And at best, Taylor Morrison's argument that our implied warranty claims are implicit in the contract is an argument that they relate to that contract. The courts have said also that, it is not enough that a non-signatory's claim relates to a contract containing an arbitration provision. And with regard to the artful pleadings, the courts, included the Austin Court of Appeals in the toll case, said claims asserting negligence and DTPA violations do not arise solely from the purchase agreement. Rather, the alleged liability arises from general obligations imposed by common law negligence and relevant statutes. And based on the substance of their pleadings, the homeowners in that case did not seek to derive any benefit from the toll pool agreement. So what the courts say is that in order to have a direct benefit situation, we have to be seeking direct benefits from the contract, meaning we have to cite some provision in the contract that says, this is, why we can collect a remedy in this case. And we haven't done that, and we're not obligated to do that. In fact, this purchase agreement makes no reference to the quality of work that is to be done by Taylor Morrison. None, zero. There's no reference to even the square footage or really the or the manner in which the home is to be built. Instead, what it does is it says any implied warranties, including habitability and workmanlike, are waived and disclaimed. So, and going back to Gupta, this is what the court says on the first page of the opinion. The Texas Supreme Court says, the question of an implied warranty under the DTPA is the only issue before us. That's it. And the court held that it specifically held that the implied warranties do cover latent defects not discoverable by a reasonably prudent inspection of the building at the time of the sale. And this is all in the context of an implied warranty under the DTPA. And the court listed out 5 policy reasons why it believed that the implied warranty would apply to a subsequent owner of the home. It says that a builder should be in the business to construct buildings free of latent defects. Number 2, the buyer cannot, by reasonable inspection or examination, discern such defects. Number 3, the buyer cannot normally rely on his own judgment in such matters. Number 4, in view of the circumstances and the relations of the parties, the buyer is deemed to have relied on the builder. And number 5, the builder is the only one who has or could have knowledge of the manner in which the building was built. And in extending that, the implied warranty to subsequent owners, the court simply said the same thing, the same 5 reasons apply to the subsequent owner. It didn't say anything about how they became direct beneficiaries of the contract. It didn't say anything about direct benefits from the contract at all. These are all policy reasons that the court stated. And I'll also add, justices, I can't tell you, this is one of the more confusing areas of the law, and that is whether or not Gupta's ruling on the implied warranties being implicit from the contract has been overturned or not by the Supreme Court is a big debate among several courts. I don't think it has been, but there are courts that specifically say, in fact, the Corpus Christi Court of Appeals rejected the same direct argument or direct benefits argument on its basis that the Supreme Court overruled itself on that issue. But again, when you talk about direct benefits, courts say, including this court, say over and over and over again, it's not enough that the claims relate. There must be a direct benefit. And Justice Lloyd, when you ask Mr. Wilkerson to cite what direct benefit in the purchase agreement that we are suing for, he couldn't do it. All he could do is refer back to another case, because there is no direct benefit in this purchase agreement. Even if my clients were the original owners of the home and were the signers of that original purchase agreement, I'd be hard pressed to make a breach of contract claim there, because there is literally no obligation set out in the purchase agreement on how Taylor Morrison is to build this home. So again, the courts have visited this specific issue numerous times, and that the issue of whether or not a subsequent owner of a home must be compelled to arbitration because the original owner has an arbitration provision. And the courts have said, look, that by itself isn't going to get it done. Just because that previous owner had an arbitration agreement, that by itself is not going to get it done. What really this argument is that Taylor Morrison is making, it's akin to the argument that Steer Wealth Management made in the Steer Wealth Management v. Denson case, where there were 2 corporations. They were sister corporations, and the plaintiff had contracts with both of the corporations. In the contracts with the corporation, or the LLC, I should say, that the plaintiff did not sue, there was an arbitration provision. In the contracts with the LLC that the plaintiff did sue, there was not an arbitration provision. And essentially, the corporate defendant in that case argued that, look, because we're related, under the direct benefits theory, the plaintiff derived benefits from the arbitration agreement with our sister corporation. And this court said, a corporate relationship between entities, however, is generally not enough to bind a non-signatory to an arbitration agreement. And that's what Taylor Morrison is doing here. They're saying that my client's relationship, if you will, with the original owners of this home, that being, in a small group of people that actually owned this home, is what is forcing them, or what compels them to arbitration. And that doesn't get it done. Also, it is very important, the fact that in
Was there an equitable assignment? It seemed that Taylor Morrison is relying on the concept of an equitable assignment, that sort of the reverse of an equitable subrogation, that you are essentially, or the Kohlmeyers are stepping in the shoes of the Davises as the original purchasers. Can you address the idea of the equitable assignment as an inverse of the equitable subrogation?
Well, first of all, I would say that even if that's what the law says, that there was an equitable assignment, Taylor Morrison took care of that problem in his purchase agreement by saying this cannot be assigned without our approval. But the Gupta court, what it talks about is an implicit part of the contract. Now, it does say that that there's it's essentially assigned to the subsequent owners, but again, we're talking about things that are not part of the contract. When the court says implied warranties are implicit in the contract, what that means is, because they're implied, they're not a direct benefit of the contract. And if they're not a direct benefit of the contract, then the direct benefits position doesn't apply.
It doesn't mean
now,
that if a warranty is implied in the contract, say an implied, there's implicit in the implication, a warranty is implied or implicit in the contract, does that exclude the possibility of its existence as an independent cause of action independent of the contract?
No, it does not, because it's still just the implied warranty claim. When you sue a builder for breach of the implied warranty of habitability, it is that. That's all you plead. You don't say by virtue of the fact that there was a previous contract with a previous owner of the home, there is an implied warranty. It is a separate and independent claim.
Right. That's what I'm saying. That Gupta blows an uncertain trumpet now, of course, but the mere saying one thing is true doesn't exclude the possibility that something else is true. That is to say, if it's implied implicit in the contract, doesn't mean it's also doesn't also exist as an independent cause of action independent of the contract. I mean, one doesn't exclude the other.
Right, I agree. I think that's, I understand your point. Certainly there's, Gupta doesn't make that connection as Taylor Morrison would want it to. And no other court has done that either. To say that by virtue of filing an implied warranty claim as a subsequent owner automatically makes you obligated for the obligations under the original purchase agreement. There's no court that says that. It's a stretch for sure. And really, if you think about the implications of ruling as Taylor Morrison wants the court to rule, I mean, it's a slippery slope. It really is. It can go, I mean, this argument can be made, can be extended to many different things. And it's on the plaintiff side too. Homeowners might start, suing for direct benefits under a contract when under this idea that the implied warranties are implicit in that contract, therefore they're, equitable assignees of the contract. And that's just not the law. Because the Supreme Court said that for one specific you know, essentially the court said the subsequent homeowners are equitable assignees of provisions that are not in the contract, therefore they are implicit in the contract. And so, you know, that language by itself tells you that, you know, that doesn't make the subsequent owners also obligated and entitled to all the other things that are in that directly in that contract. And you know, that's why going back to the language that the Supreme Court, you know, told us about in Weekly Homes, and this court told us about in, you know, numerous other cases about having to be a direct benefit. In other words, you know, if you don't plead that breach of contract, your case is gone. And that's not the case here. That's what the courts say. If you know, the claim is dependent upon and you have to plead that breach of contract claim or you don't have a lawsuit. And that's not the case here, as other courts have said with our common law claims. Thank you.
Thank you. So now we're back to Mr. Wilkerson to wind up. I think you have 3 minutes.
Thank you, Justice Keys. What is the direct benefits, or what are the direct benefits that appellees seek? They seek economic loss damages. When the injury is only the economic loss to the subject of a contract itself, the action sounds in contract alone. That is from the Jim Walter Holmes versus Reed case.
Breach. Yeah.
Pardon me?
If the damages are direct loss under the contract.
Yes, Your Honor. And the damages that are requested are repairs to construction defects, mold remediation, rebuilding after remediation.
But aren't these kind of tort? Aren't these claims kind of sound in tort?
No, sir. Those are all economic loss damages that are solely recoverable in contract. And that also addresses the negligent construction claims. The only
part of the issue, Mr. Wilkerson, is that you're asking the court to sort of upend a number of first principles. For instance, that arbitration clauses can't bind non-signatory. So we have to find an exception to that. We have to find an exception to a disclaimer of an assignment. Now we also have to find an exception to what the Supreme Court said in JCW Electricals versus Garza, that implied warranties are created by operation of law and are grounded more in tort than in contract. So the warranty may exist because of the existence of a contract, but they're not. But the gravamen of the cause of action is tort rather than contract, and they're not necessarily part of the contract. So I think you're asking us to do a lot of implication and a lot of sort of first impression gathering into the contract in order to enforce the arbitration clause. And what is your best authority for making us make all those implied assumptions?
Well, first, the Jim Walter Holmes case, which identifies that when economic loss damages are requested, such as those requested here, that the claim sounds in contract. And then the next are the Texas Supreme Court cases discussed in appellant's reply brief. And then lastly, as a pièce de résistance, then I would cite this court's opinion in the Mitchell case, wherein this court said that an underlying cause of action that allows for the recovery of, for example, attorney's fees is necessary. And it's not the statutes that comprise the Residential Construction and Liability Act that allow appellees to recover all of the economic damages that they're requesting here. It requires an underlying cause of action that affords that recovery. And then going back to the Jim Walter Holmes case, that is only in contract. That's the economic loss rule. So
Thank you.
appellants pray that the court reverse the trial court's order and that this court remand proceedings to the trial court with instructions to send this case or to arbitration.
Thank you both for participating in this Zoom oral argument. I know it has inconveniences for everyone. Case number 01-19-00519 Taylor Morrison of Texas, Inc. versus Andrew Kohlmeyer is submitted. Thank you very much.
Thank you.
Thank you, Your Honors.